Picture this. Bonnie Lake, Washington. A quiet neighborhood called Chinook Meadows. It's got 400 regular homes and 30 large 5-acre lots on the edge. For over 20 years, hot air balloons have been landing here. It started back when this was just farmland. Even after the houses went up, the balloons kept coming. And nobody minded. Parents would pull their kids outside to watch. Neighbors would wave at the pilots. It was one of those small-town moments that made people feel like they lived somewhere special. Under federal law, these landings are legal. The homeowners with 5-acre lots were fine with it. It was part of life here. Then a new HOA president named Whitley took over. And that's when things got weird.
One morning, Whitley sends an email to all 400 homeowners. The subject line is simple: no aircraft landings. In the email, she writes, residents are not allowed to let balloons land on their property. Residents should take steps to stop it. On the surface, it sounds like a typical HOA rule. But here's the problem. Interfering with an aircraft landing isn't a HOA issue. It's a federal offense. We're talking serious fines, possible jail time, and a federal record. And the bigger problem? HOAs don't control the airspace. Not even a little bit. The FAA does. A neighborhood association can't regulate planes, helicopters, or hot air balloons any more than they can regulate commercial airlines flying overhead. But Whitley didn't stop there. A few days later, the board holds a meeting. And during that meeting, two things come out. First, the board admits the community's governing documents, the CC&Rs, don't ban aircraft landings at all. Second, they admit that emergency and safety landings are 100% legal under federal law. So you think that's the end of it, right? Wrong. Instead of updating the rules properly or finding insurance that covers aviation activity, the board does something else. They pass a board rule banning all aircraft. Why? Because their insurance company dropped them after finding out balloons and helicopters had been landing here for years. The board wanted to get new insurance fast, and the cheapest option was a policy that excludes aviation entirely. So they changed the rules with a board memo. No vote from the homeowners, no amendment to the governing documents, just a rule passed by 5 people.
But they didn't stop there. The board decided to split the neighborhood into 2 groups. For 400 homes, the ban was immediate. For the 30 homeowners with 5-acre lots, they said, you can vote later if you want aviation in your phase, and you'll pay more for insurance. The board even voted on behalf of 400 homeowners without asking them, saying those lots are too small for aviation anyway. And here's where it looks personal. One of those 5-acre lot owners legally owns a helicopter. He has a legal hangar built on his property. It's been there for years, and it's allowed under the current CC&Rs. But now he's being singled out. Legal experts call this selective enforcement, and it's one of the fastest ways an HOA ends up in court.
So let's be clear about what's happening here. Emergency landings will still happen. Federal law doesn't care what the HOA board writes in a memo. One homeowner still legally flies a helicopter. The same aviation exposure still exists. What's changed is that the HOA is now likely uninsured. They've changed property rights illegally, and they've opened themselves up to a lawsuit. And if that lawsuit happens, who pays? Not the board members personally. The entire community pays. Higher legal fees, higher insurance costs, and any damages awarded come straight from HOA funds. That means your monthly dues go up for a problem the board created. All because one president didn't like hot air balloons. Drop a comment below. What's the most over-the-top thing your HOA has ever tried to control? And if you're on this board, it might be time to call a lawyer before the FAA calls you.